sure to say good morning or good afternoon. That's 12:04. Good afternoon. Welcome, everyone. This is our meeting today for the City of Fitchburg Board of Review. I have in front of me the agenda. The first item on the agenda is a call to order. I call this meeting to order. And Madam Clerk, would you do a roll call vote to make sure we have a quorum?
Thank you, Chair. Chair Coulard,
Here.
Elton Krim Jr.,
Here.
Sean Paff is delayed, Carol Poole, here, Sharif Batoon,
Here.
Rich Tate,
Here.
Andrew Slegler,
Here.
Nicole Buffarati.
Here.
You have a quorum.
Point of curiosity, Nicole, I'm not sure why we're looking at you instead of having you by my side.
I am only sitting here out of precautions. Someone in my household tested positive for COVID. I myself have tested negative twice, but I like you all, so I don't want to get anybody sick.
Thank you for being cautious.
You got it.
Madam Clerk, as always, I ask the question, has this meeting been properly noticed?
It has been properly noticed on the door to City Hall per state statute.
Perfect. Hearing that, first item on our agenda that requires review, approval of minutes from August 29th. The minutes were sent out with the basic information. Hopefully everyone's had a chance to review them. If not, there's also a copy in your packet. Does anybody have any comments, additions, corrections, or changes to the minutes after reviewing them? Hearing none, I'd ascertain a motion to approve the minutes as submitted.
Move approval of the minutes from our meeting on August 29th.
Second.
I have a motion and a second. All those in favor, please signify by saying aye.
Aye.
Opposed?
And I'm abstaining since I was absent.
Okay, please let the record note that Rich was not here, and so he is abstaining from the voting on the minutes. Agenda item number 4, request to eliminate a double assessed property. A duplicate personal property assessment account was found on the roll.
Yeah, thank you, Chair. This is just one, the account number 97400 was one that I had discovered. It looks like there was just an addressing mix-up. So there's two that got put under, they're different addresses, but it's the same parcel, and it's the same account essentially. So this one is the one that was damaged and needs to get knocked off the roll because the other one they submitted the form on. I think when they submitted it, they put 403, and somebody must have created an account specific to that address, even though it covers 401, 403, and I think a couple other addresses on West Beltline Highway. So this is just a duplicate account that needs to be pulled off the roll.
Okay, you used a term I'm not sure members of the board understand. He said it was a doomage assessment. That's an assessment by default, meaning that the assessor did not get the personal property report back indicating the assets that were taxable. So they make an estimate. Mm-hmm. So this is the value that you're asking to have removed, is the doomage assessment, because you did get the official report just showing a different address.
Correct, yeah.
Okay. And the amount of change is?
$1,500.
Any further questions of the assessor? Hearing none, then I'd make the motion that we strike from the personal property assessment roll account number 97400, the amount of $1,500 as a duplicate assessment.
Second.
We have a motion and a second. Any question? Hearing none, I'll call the roll. All in favor signify by saying aye.
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 Opposed? Let the record note, item 4 was approved unanimously. Item 5 on our agenda. Proceed to hear, deliberate, and determine the following commercial objections for Reinhardt, Borner, and Van Duren. A and B, both Hatchery Hill properties. 5550 Cadis Bend, 2981 Cadis Bend. The representative is here. Good morning.
Good morning.
I'm sorry, good afternoon.
Good afternoon.
Past the witching hour here. Welcome. Would you please state your name for the record?
My name is Attorney Sean Lovell.
Okay. And you are the authorized agent for the property in question?
Yes.
At this point then, if we're going to hear the case, I'll ask the clerk to swear in all parties.
Mr. Chairman,
Yes.
this is Amy Seibel. I represent the assessor, as the board knows, and I would ask for permission to speak before we start the valuation hearing.
Any objection? Go ahead.
Members of the board, this matter was set for a valuation hearing today. The valuation, the property involves an apartment building, and there's confidential income and expense information that would need to be disclosed in connection with the valuation hearing. And because this meeting was set up in advance to be televised, we are concerned that confidential information, which the board has to keep confidential as well as the assessor's office, would be disseminated into the public. So our request is that the assessor has prepared a waiver request to waive this matter into circuit court. Although the matter is not currently pending in circuit court, the board did issue a subpoena, and there was really great information that was provided, including an appraisal report that the assessor has reviewed, and the information was found to be in support of the assessment. And therefore there is not a reason to have a valuation hearing. And if there is a valuation hearing, we would ask that it be scheduled on another date when arrangements can be made where it's not all publicized. We take very seriously the city ordinance and the state statute that income and expense information must remain confidential, or otherwise taxpayers would be reluctant to provide it to the assessor. And this information, of course, is very helpful to determine fair and just assessments throughout properties in the city. And therefore, before the days when these matters were publicized and put out and broadcast, we would ask board members to return any income and expense information that was provided so that it would not be disseminated into the public, and it would be put in confidential folders and protected. Since this meeting is being publicized and there was no way to stop it at the last minute, we would ask that the board accept the assessor's waiver request, which he's prepared and he can hand. I can't see what's going on, but he can hand to the board members for consideration. And I would remind the board that the taxpayer had requested a waiver at the last meeting, and the board had declined to act on it and to have a valuation hearing. But I believe that there are intervening circumstances that we would like the board to reconsider that decision.
My question is, why didn't the assessor prepare a summary of the information, using it specifically to help establish or confirm his value, so that this confidential information would not have to be made public via the fact communication network?
Well, the concern is that if there is just a summary of information without the basis for the income approach, without providing actual income and expense information, that is the board record. And it's possible that instead of starting off from scratch in circuit court, that this record could be then appealed to circuit court. and possibly the decision of the board overturned because there was insufficient data supplied by the assessor as far as the details of the income and expense. And so it may not be sufficient just to have a summary to say the assessment is X and we believe it's correct.
So based on what I'm hearing, we have two options. Option A is to receive a waiver request from the assessor and waive this to the next level of review. Option B is for the board to say, we understand the confidentiality of the documentation, and if we want to see it, we would then have to postpone this case to another time and date, and then bring it up without having Fact TV broadcasting the documents in the case. Is that correct?
That's correct.
Okay, I'll bring it to the board then. We have a decision to make.
If I could comment on that before a decision is made or discussed.
Go ahead.
I got a call from Attorney Seibel this morning about this. I discussed it with my client. We are prepared to proceed with the hearing today. I know there were discussions previously when we requested a waiver, and I believe it was someone over here who had commented on why someone would do that, and we kind of explained that obviously there's cost savings in not having to come back, prepare for hearing. We've done that, and now the city assessor or through Attorney Seibel is asking to waive that. So our time and effort has already been put in, so we're prepared to proceed. So although we previously requested a waiver, that's why we're not agreeing to waive today. We'd like to proceed. I don't know the technical issues with as far as the television works and how it's broadcast, is whether or not that can be turned on or off. But I've appeared before the board a number of times, and for the assessor to now want to push this off yet again, it's certainly getting frustrated and expensive.
Mr. Chair, is it possible to hear from our attorneys, us?
Well, yes, it is.
Just to get
But
her.
I can tell you that I have had several conversations with her in the last 2 days,
Sure.
and one of the concerns has been public dissemination of confidential documents. And in discussing briefly this morning with our Fact TV staff, they have told us they can shut this down and end the broadcast and just create the record. The only concern they had was, how would that record then be stored? Since it would be a different process than having it as part of the Fact TV files. So it can be done. Question is, at this point, what do we want to do?
Mr. Chair, are we not prohibited by law to go into what then would be a closed session? I thought all of our...
It's not a closed session.
Okay.
The documents would still be, this is a public hearing, people could be here. It just means that we would not be broadcasting confidential information over Fact TV so that anybody and everybody could hear it.
Thank you.
So
And
those
how is-
documents would then stay with the clerk as part of the part of the record. And if there are documents that are deemed under Wisconsin ordinance, under Fitchburg ordinance as confidential, they would be collected, given back to the assessor. They can do what they need to, which might be given back to the property owner.
Thank you.
In the previous hearings, did we not hear any information in those that were confidential?
You're not coming through my hearing.
Oh, I'm so sorry. In the previous hearings, did we not hear anything that was confidential information? Like those were all broadcast?
Yeah, to that point, no. There was nothing that I would consider confidential. We're talking now about specific income and expense information,
Gotcha.
and that's what they're trying to make sure is proprietary information. They don't want it broadcast to everybody who has access to Fact TV.
Gotcha. Thank you.
Mr. Chair. If we could, could we get our attorney, Amy, who represents this body up here, just to help give us some direction here, if that's possible? I think we need Val. Yeah. Val, I'm sorry. Yeah, of course. Sorry about that.
Hi. Here. Good afternoon. As you've heard, there's been a request by the assessor's attorney to continue this matter. I would tell the board that you have some options here, I think, as the chairman has laid out. I think the board does have the ability and authority to grant this waiver as requested. It's given to it by statute, Wisconsin Statute 70.47 sub 8M. It gives the board authority to waive and to grant a waiver hearing request. So if the board wanted to proceed that way, the board could. I think the other option would be to, as requested, continue this matter to another date so that these arrangements could be made. I do think that there are technological, I think, challenges in creating a record. My understanding is the broadcast can be shut off. However, after it's done, there's going to be some other portions of this meeting that would be subject that aren't subject to this confidential limitation. And so the concern I think the city has from the city's perspective and the technological perspective is if there's an open records request down the road or if this is restreamed, how will we handle that? I apologize that this is late in the game for the property owner. And my understanding is we don't have a ton of income and expense confidential information hearings, so it's not really something that we often do. And so I don't know that everyone was prepared to do that. And maybe we can make better planning on the part of Fact TV and make those arrangements in the future. But I think the concern is we can shut off the broadcast today, but if there's a records request down the road, there may be an issue in terms of editing it. The city will deal with it ultimately, but it may create some staff challenges in terms of editing that record and the rebroadcast. So that would be another option, is if we proceed today, we can turn off the broadcast. Another option is that the property owner can, waive those concerns if they're not concerned about that being broadcast and they're presenting that today. I think ultimately it's their information that is confidential, and if they're comfortable with that hearing being broadcast or potentially being part of this record that's recorded by Fact TV, and that's the preference to proceed today as opposed to waiting, that's something they can voice, but I think we'd want to hear from them. That said, again, if the board's inclined to grant the waiver, I think the authority is there in the statutes. I hope that helps.
I'm going to address
Clear
that.
as mud, right? So I'm going to ask the taxpayer's representative, are you okay with the documentation that's being presented to the board that they're saying, the assessor staff is now saying is proprietary as part of your exhibits and your documentation in support of your opinion of value?
So I know what I am planning to submit, and I'm comfortable with that being broadcasted, and that does contain basically the first page of an income workup based on some income and expense information, and I also have some other market data. I don't know what the assessor intends to submit to support their assessment, and so I guess that's kind of a bigger unknown, because if they're going to be putting in all kinds of other stuff, that would be a concern, and we certainly wouldn't want that broadcasted. As I had indicated, if we can proceed today, we're more than happy to. We have limited information that we would be presenting that we believe that we would be comfortable if it were part of the record. If it obviously needed to be, we would be okay with that. Because of the unknown of what other information they might put in, I don't know. But I can tell you that with all the back and forth, we're prepared to go forward with the hearing today. If we need to come back for another hearing, we would just might as well agree to waive it. So if we can proceed today, great. If it's going to get rescheduled, we would then join the request to waive it. But otherwise, we're prepared to go forward today.
I guess then I'll address the assessor. Of the confidential information on the finances of the property that we're reviewing, will you be including documentation in your presentation that would be considered proprietary and that the taxpayer would have concerns with being public record?
I would say yes. There's part of our subpoena request, I believe it was last month or maybe the month before, was for, property-specific income and expense data. And in the information that was submitted, the property owner had indicated that these, on the pieces of paper, indicated that it's confidential information. So to my eye, yes, it would include confidential information.
Question for our attorney, Val. So we can't have it halfway, right? We can't kind of do half the hearing, and then if there's certain stuff we would for sure have to come back to another thing. We can't start this today.
We could start this today. We just tell, the law requires us to have a recording of the testimony as presented. It does not have to be published on Fact TV. So we could turn off everything today. We could turn off Fact TV and let the presentation begin. It would be presented to the board. It would be confidential information. It just would not be broadcast to the world. So that's certainly an option.
Are there any
And
legal
then we would
concerns?
shut down the whole, not just one presentation, one case. The whole Fact TV would be turned off and just used as a recording document for the record of the board. And that's the way I'm leaning at this point.
So I just have a question. So if we go forward, I'm feeling a little bit like it would end up being a little discombobulated, and I'm wondering about the quality of the record for when it does end up court. Then have we provided a hindrance for the assessor when the appeal ends up in court anyway?
Well, let's ask the assessor, are you prepared to present testimony today?
I would, with confidential information. I would need, 10 minutes to print off some more packets of information. I wanted to kind of wait to see. I've got a PDF ready to go to print, should you all choose to go that route, but I didn't want to waste a bunch of, trees and paper unless we were going to go for it. So I would be ready, but it would have confidential information, and yeah.
So, if I may, just in way of conversation, it feels like as a board, it is our job to discuss and solve these at this level. And we decided, I believe, last time that if it wasn't already being discussed in circuit court, that we were going to try and discuss it here. And as the taxpayers' representative has stated, they took the additional burden. So I would be in favor of stopping the broadcast. And although I acknowledge that that's an additional burden on city staff to edit later and make available, I think that burden is the right move because we've already put the burden on the taxpayer to prepare a presentation for today. And I feel as though that is the charge of our board, just from my perspective.
If we were to go in that direction, that Nicole is recommending, and I think the chair is leaning, should we adjust the agenda, put this issue at the bottom of the agenda so we can do the other stuff on our meeting in public first, so the public can see the other items on the agenda?
I think our goal would be to keep it simple. And I think by having just the record of the Board of Review recorded by fact and not broadcast would be the most logical and simple way for us then to later come back and get the documentation, if necessary, to provide to the circuit court if it does go to court.
If we go forward and hear this case, do we have to come back as a body? Or is our job done for the year?
I guess it depends what else is on the agenda.
Mr. Chair, are there any rules and regulations that are we violating anything if we don't broadcast publicly the other items on the agenda?
No, as I said,
Okay,
there's no
thank
law
you.
requiring the public publish this or broadcast it on Fact TV. That's something that was decided as a community service, I believe. The law does not require it. The law requires we have a recording. It could be by a tape recorder. In this case, we have video equipment, which is much nicer naturally. But there's nothing specified in the law saying that we have to broadcast this to the public.
Do we have other cases today that are going to be arguing this same basis so that it would make sense to just turn off for the rest of the whole meeting?
I'm just looking at the agenda. I looked at the draft, and last time the draft changed before I got here, so I want to make sure. Yes, City Attorney.
I think what Member Pfaff is suggesting is that this matter be heard last so that the broadcast can be shut off and then the public can watch the rest of the meeting as they ordinarily would, and I think that certainly makes some sense. I also think that would make the redaction of that recording easier at the end, because then that portion could just be cut off in the event that there's any record request down the road that would request this meeting. So that's a viable option if the board is inclined in continuing with evaluation hearing as opposed to granting the waiver.
Okay.
So under that, we'd put item 5 at the foot of the agenda. Do the rest of the
Correct.
business.
But again, I would defer to the board in terms of the decision that the board wants to make, whether that motion to reconsider by the assessor's attorney is granted, or if the board prefers to proceed to evaluation hearing. Then I think if that motion is denied, then the board can then entertain a motion to move this item to the end of the agenda. If that's the direction you'd be inclined, then you can vote on that.
I saw the quiet authorization from Fact TV indicating that doing it the way our attorney has suggested would be the best option,
As recommended by Member Papp.
as recommended by Member Papp.
I think, though, Mr. Chair, just to answer this question first, I would make a motion that we reconsider our public hearing and accept the waiver request that the city assessor is suggesting. So we do not have the public hearing. Just move it on to circuit court.
I would be in favor of seconding that motion. I feel like we're doing stuff very different than we usually do, and that would create an issue down the road. Courts tend to look at like consistency of process.
So Eldon, to your point, I'm the one that, full disclosure, I'm sure we all, but I'm the one that pushed it last meeting to have this thing in public. Just because, but now I've thought about it, want to make sure the attorney for the assessor makes a good point, well respected in her field. We want to make sure that if there are documents that are confidential, I totally know we're giving the zig and the zag here to your client. I get it. But I think for us, this body, to keep the integrity of the process, the appeals, the confidentiality, not to put our Fact TV friends in any difficult spot, even though they can successfully do their jobs because they're talented, I would suggest that we reconsider and move this on to circuit court. As someone who believes in the authority of this board, saddens me at times to give up a little control, but it is what it is. And I would suggest that you join Eldon and me in supporting this.
So we have a motion and a second?
We do.
So, to restate that long motion, basically, Sean, you're moving to move this to circuit, to undo the decision from last one and move this to circuit court, correct?
Valerie, can you help me? What did I ask?
What we need then is the assessor to submit the waiver request. We have not received that yet.
Okay. Is that what I'm asking, right?
That's what
That's
you're
correct.
asking.
I think the board would reconsider its prior denial of the waiver request and then vote to grant it.
And I am sorry. I mean, we are zigzagging on you, and that was not our intention.
No, it wasn't.
Understood.
I appreciate your flexibility, and here we are. I don't know what to say. I'm sorry. So we have in front of us a request for waiver from the assessor of this particular case, which is, I'm sure we have the right documentation, Hatchery Hill LLC, located at 5550 Cadiz Bend, 2981 Cadiz Bend. After discussion and consideration, advice from our city attorney, we have a motion to accept this waiver and send it to circuit court instead of having a hearing today to determine at the board level what the value is.
I believe you entered or read the address wrong. It's 2981 Cahill, Maine, and 5555 Cadiz Bend.
I'm sorry. Thank you for the correction.
So it's agenda items 5A and 5B. Got it.
Any further discussion? So if everybody's clear, at this point, we have a waiver request from the assessor. We would be considering this request as whether or not we hear the case today or send it on to circuit court. All those in favor of this waiver request signify by saying aye.
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 Opposed?
Nay.
Nay.
Please let the record show that it was approved, not by unanimous vote, but with two nays. Hearing that, I will sign it, and we'll pass you on. I'm very sorry for the inconvenience. We had full intention of hearing this. This was brought to my attention just this morning, so
Understood.
that's why our city attorney is here, to give us guidance, because I didn't want to make a wrong play and then find somebody going into circuit court with a problem that we didn't intend to create. So, thank you.
To that point, may I just add, I think in the future, I'm saying this with many grains of salt because I do not have any of these jobs, but it might be a good thing that when waivers are brought to the board, if we do anticipate confidential information, if it is known by the assessor's department, to bring that up when we are considering it so we can save the taxpayer some time and money, because it does feel like we kind of went back on that. Again, the majority has made the decision that we feel is right, and I feel like we're moving forward in the right direction. But if we could think about that next time, I think that would be great.
Noted.
Please pass this to the city clerk. And we are set to move on to agenda item 6. Subpoena compliance review and possible consideration of waiver request from Reinhardt Warner Van Duren. Property 6A, TMJ2 LLP, with a list of parcel numbers that looks to be about 7 or 8. Also, agenda item B, TMJ2 LLP, with 1 parcel number. On page 2, agenda item C, Simbrick Buick, parcel number 0709 3449402-0. And then Bowman Farms, Inc., parcel number 609-031-8815-2, which was withdrawn. So seeing that D is withdrawn, I will check that one off. Going back to A and B are both TMJ. I'll defer to the assessor on the information they got from the taxpayer on this parcel.
Sure. Thank you, Board. So with these, there are some apparent issues with the subpoena compliance. One of the subpoena requests, or one of the bullet points on the subpoena was, let's see, so this is for 306 East Badger, Round 1A, or 6A. Let me double check here. There was a request for copies of any, let's see here, documents that reflect any deferred maintenance. Let's see here, hang on, there's one specific one. Oh, sorry. Bear with me just a second here. So there's an overarching kind of theme with some of these. These are all for just different Zimbrick properties. 306 East Badger Road is for Zimbrick Mercedes. In the documents they provided, they included a number of or a few pages of what's called an AIA document. It refers to construction costs, and that was not specific. Let's see here. There was the same document was included across all 3 properties, I guess is where I'm trying to go with this. And so I was confused as to why it was included. I noted in an email a few days ago to Attorney Don Millis some of the discrepancies that I had found with respect to these. With regard to that, the AIA document that was included on this Zimbrick Mercedes parcel, 306 East Badger Road, I was curious, since it was included on all three parcels, did it include costs for all three parcels? They cleared it up that no, it did not. It was included by mistake on the other parcels, and it was specific to this property, which is fine. However, one of the other things we had subpoenaed for was a number of, copies of receipts for any, things that had been fixed, deferred maintenance that had been addressed, and all of those were specific to 1601 West Beltline, a separate Zimbrick property. There were none included on this specific parcel for 306 East Badger Road. To my eye, then, and they were aware of that there was discrepancies that we had not, where they were missing documentation for 306 East Badger Road, and no additional information was provided for the correct property. So, to my eye, this has not been sufficiently complied with, and as such, we would request that that the board dismiss this hearing or case.
So you want all of them dismissed, or just?
Just this one specifically for now. There's issues with the other ones that are specific to them as well, but in the interest of sticking with each specific agenda item.
So we are looking at the appeal that's specifically for
6A.
306 East Badger.
Correct.
And is this just for one parcel?
So it's technically, I think, 7 or 8 different parcels. They're all assessed together. The main parcel is 0709-362-4152-0. The parcel lines on this property are quite odd. We can pull them up on a map if you'd like, but yeah. So it's all 7 parcels, 7 or 8 parcels, whatever it is that's listed on there. They all correspond to the same property.
So you're asking for what?
So my suggestion would be, to put it simply, the subpoena request has not been complied with. I would request that the board dismiss this hearing based on that.
Dismissed to circuit court?
Dismissed altogether. Because they have not complied with the subpoena request.
Okay.
Or sufficient.
So not go through with the hearing because we don't have information through the subpoena?
Correct. The city requested specific information on this property on the subpoena, and not all of it was provided.
Okay, understood. I did have another technical question on this parcel, but if we're going to dismiss it, I guess it's not an issue.
Do you want a motion, sir?
If I could address the concerns, please.
Certainly.
I am aware of the email that the assessor sent. Looks like we got it from Attorney Seibel on Monday with a number of questions regarding their concerns with the subpoena. We addressed all of those questions and answered all of those questions. So I guess I'm a little confused if the assessor had concerns with the sufficiency of our response, why it wasn't raised in the email that we received on Monday about that, because we were basically given a very short deadline of less than 24 hours to get responses. We jumped through those hoops. We got those responses, provided them, and now we're just learning for the first time that that's inadequate. I'm also unclear of what specifically he's indicating was requested and not submitted, because just because a document was not provided doesn't necessarily mean a document exists that was not provided. So if there's something that we previously indicated, we don't have any responsive documents, that wouldn't be a reason to say that it was not complied with if we can't create documents. So I guess I would just like a little bit more clarification on what specific subpoena item numbers were requested that the assessor feels were not complied with.
I'll defer to the assessor
Sure.
to respond.
So subpoena item on the subpoena issued on August 29th. Item 3 says, copies of any costs incurred to repair or improve the subject property incurred during any time between January 1st, 2019 and December 31st, 2022. On 1601 West Beltline, there was several pages in the email. I noted pages 9 through 33 of the subpoena response document we got on 1601 West Beltline, which were receipts, invoices, for all sorts of improvements that were made to the property. On 306 East Badger, there was none of those included specific to this property. When evaluating something on a cost basis, those repairs, improvements are very valuable, and we have been given no evidence of those repairs or anything that was made. Now, if nothing has been done there, then I guess they would be in compliance. But
I guess my question would be whether any permits were pulled. I mean, that would be, if there weren't any permits pulled, stands to reason that there probably wasn't any significant improvements. I mean, they may have done something, I don't know. I think part of the confusion as well, and that was kind of explained in the email to the assessor in response to some of these follow-up questions from Monday, is that with all these parcels, different names, basically all owned by Zernbrek, different dealerships under different headings or different entity names, a lot of the things are done an umbrella as a group and not necessarily specific to one. So until we figured out this issue just recently, when we provided the responses, we indicated that they were being provided. Apparently they had related to a different property because of this umbrella that they were providing it under. So first question being whether or not there's any indication on any permits pulled that there were any improvements that weren't provided. Otherwise, I'd say that probably isn't relevant and we have complied with that. If there was, then I would just ask time to be able to talk to my client to see if we can unwrap this, because we were given a very, very short deadline earlier this week to find this out. And there wasn't any question of, hey, this wasn't provided. It was, hey, can you clarify this? And we answered those questions. So this is the first we're hearing of it.
So as to the permits, this is all three of these properties were Township of Madison parcels. And I reached out to our building department. I asked them specifically if they had any records of any permits that were given to them from the township, and they said no. But the way it was described to me was that when the township dissolved, all of the building permits got taken to the city of Madison, and there was a lot of mix-up in that shuffle. So I don't know that there's not any permits on this. I know there have been renovations ongoing, maybe not ongoing, but that had taken place throughout the years. I don't know specifically what was permitted and what was not. I tried to take a look, but our building department had indicated that they have some Township of Madison parcels permits, but very, very limited amount, as a lot of it got lost in translation.
Not a smooth transition.
No.
So just a clarification, just for the board here. When you say dismiss, what does that mean, and what does the tax roll look like, and where does this go? What does that define what dismiss is?
So should the board choose to dismiss this?
Per your recommendation.
Right. Should they choose to dismiss this per my recommendation, they would lose their appeal rights. The assessment would stand as is.
Mm-hmm. Not making this easy for us today, Chris. We've got some tough calls here.
And to restate that, we do or don't have an idea of like a specific improvement that we believe the taxpayer made, whether it's based on building permits or something that we're saying, hey, we expected to see a piece of paper stating these costs or incomes or whatever, and we didn't receive it. We don't have a permit that they pulled that we don't see corresponding paper to.
So let me try to think about this for a second. So we don't have any permit records. If we did, that would make this a lot easier. Mm-hmm. However, we have, my thought is that we have close to 30 pages of invoices for property-specific repairs improvements on 1601 West Beltline. And they're all large-scale dealerships, and I know, specifically relating to car dealerships, that typically they require certain standards to upkeep. They can be expensive to maintain them. There's, like I said, there's standards of improvements that they have to maintain to keep their whatever dealer is or whatever auto group is in there. So I would likely believe that there's some sort of invoices for improving the property. Again, like I said, I don't have any specific permits to cite that would give me that impression, but based on my, the years that I've been doing this, I would assume that there's been some work done there, and we've gotten no indication of that with the subpoena response.
And I guess I'd just add, to the extent that there isn't any definitive belief or proof of some permit existing that we haven't provided documents for, I think it would be unfair to just unilaterally dismiss this, considering this is the first time we're hearing from the assessor that he's claimed that this is deficient. Like I said, we were previously in communication earlier this week, and this was not addressed. So I would request time to be able to consult with my client to find anything. The assessor can then consult with the township, whatever he would need to do to see if he can find any other permits. But I think it would be unfair to dismiss this outright at this point, just upon learning this.
Question, Mr. Chair, for Amy, the attorney. Is the property taxpayer making a point that the timeline was too constrictive? Do you think that extended time frame, what would that do for the assessing department, or is it just a fait accompli that they're not going to get the information, and it is what it is?
I believe that, I think the time was sufficient. However, as the board will hear, there's some other matters that the board will need to reconvene on as we get further through the agenda. And this information only exists within the hands of the taxpayer, since the city doesn't have any kind of records that it normally would have as in terms of permits. It's my understanding also that the assessor did, after the response was received on Monday, the assessor did reach out and tried to call Attorney Millis, and I don't believe got a call back. So it's probably not a true statement to say that this is the first they're hearing of it, because the assessor did try to reach out. But in the interest of getting the information that's helpful to arrive at a fair assessment, we would not be opposed to allowing them more time to meet with their client and to gather the necessary information so that the assessor can do a thorough review of the assessment of this property. We would not be opposed to that.
More time is 30 days, 45 days? What is more time?
No, we got to get this board closed.
I'm thinking a week.
Okay, great. I mean, let's close it up.
1 week.
2 o'clock this afternoon? I would make a motion.
Well, let's make sure we got our ducks in a
Okay.
row. I want to make sure, as we look at the parcel addressed as 306 East Badger Road, that is strictly the Mercedes building. It does not include any other building like what used to be the BMW, now Audi dealership across the street.
Yeah, I think it's Zimbrick, I think it's Porsche, Mercedes. The Audi dealership is a separate parcel to the south. That's 2400 Rimrock. That's a separate agenda item.
Okay.
But yeah, this is specific to that. Again, it's 7 parcels. It's one economic unit. Call it that.
And I just wanted to clarify one point to the comment Attorney Seibel said about having sufficient time. I'm looking at the email. The email from Attorney Seibel was provided to myself and Don Millis at 8:26 p.m., indicating we needed to respond by noon the very next day. We responded at 11:50 a.m. the next day. So I would argue that time is not sufficient time. And I would agree with Attorney Seibel that additional time to provide it. We have provided it for some of the other properties. I have no reason to believe that our client wouldn't provide that type of information for this specific property if we have it, if it exists.
Thank you for your clarification. So, back to the board. The assessor's recommendation is to deny the appeal based on insufficient compliance with the subpoena. After hearing the discussion from all parties and the time frame that was discussed, we have to make a decision if that was insufficient time and grant them more time to comply, or if we say they had adequate time, and if they had questions, they should have reached out to the assessor when the subpoena was first sent to them. So let's discuss your feelings, please.
I think we should I would suggest we give them more time. I mean, 2 weeks.
I'd rather err on the side of caution and I want this to be a fair process. So I think we need to accommodate both groups.
I would agree. I don't perceive from 8 p.m. to noon the next day sufficient time. And I think in the future, we also need to make sure if there are follow-ups of, hey, thank you so much for that, but I don't find that sufficient. The follow-up needs to be in the same email communication, right? So that the board has sufficient information to say, well, you were given a chance to respond, but you didn't respond. So I agree with both Sean and Rich that I believe we should give them more time.
Well, you know what that means? It means we'll be setting another date.
That's okay. Tracy loves that, right? So, Chris, what property, just so we have it right for the record, are we dealing with? Agenda item, which one?
This would be 6A.
So thank you. I would make a motion, if Mr. Chair you allow it, that we delay, is that the right word? Or postpone until October 15th. Is that too long?
Too long.
All right, well,
A week.
That
should be adequate time, isn't it?
It should be, yes.
Okay, I don't know, October, what is the week? October 6th? All of next week. So what's Monday the 9th? Until Friday, October 6th. Sean, does that work?
Assuming I can get a hold of the client, it should be fine. It should be sufficient.
So, Nicole, how do I want to word this? Go ahead, you do that.
Oh, I was just going to second you. I move that we we postpone the subpoena compliance review and waiver request for item 6A for 1 week, giving the taxpayer until October 6th to provide the sufficient documentation.
Second. Thank you.
Everybody clear on that? Giving
Chris,
us till October 6th?
Yes.
Okay. All in favor signify by saying aye.
Aye.
Aye. Opposed? Motion carries. Thank you.
You guys don't want to do Thanksgiving Day here?
Only if you're buying a turkey.
My favorite holiday. Got some big screens.
Agenda item 6B, parcel number 709-363-2123-0, address 2400 Grimrock Road. So this would be the Audi dealership?
Yep. So basically the same exact scenario. There does not appear to be compliance with subpoena item 3. Copies of any costs incurred to repair or improve the subject property incurred during any time between January 1st, 2019 and December 31st, 2022. In the subpoena response for this parcel, the only invoices that we received and receipts were for 1601 West Beltline Highway. Again, this is another one where I suspect that there is invoices out there, but we have not gotten those, so I would say that this subpoena has not been complied with, but in the interest of what you all have just chosen to do with the other one, I would be fine with another if we wanted to give them a week on this one.
Okay, so as in the last one, building permits transition didn't find their way to the city staff.
Same thing, yep.
So it's a repeat of what we had before. So since we set a pattern, are we going to follow that pattern and defer this one as well? Or postpone it?
Does the property taxpayer need extra time? Or?
No, I would think another week. And just for the record, this property, along with all 3 on the agenda, we're addressing that same email that I talked about earlier this week. So all of the stuff that previously addressed applies to these.
So that being said, I would make a similar motion to,
Well, should we just postpone all of 6 because they're all the same?
well, that's a good
Would
question.
that be,
Look at them one at a time.
Yeah,
All
they're
right.
specific on
Okay.
1601 West Beltline.
So I'll make the motion to postpone the decision on subpoena compliance review and possible consideration of waiver for item 6B until October the 6th, giving the taxpayer an extra week to provide sufficient documentation.
Second.
Maybe we could make a friendly amendment. What time on October 6th?
That's a really great point.
Close the business.
What?
Close the business.
Close of business, end of business, so 5 PM?
Well, that means the assessor won't get them probably till Monday.
Oh, fair enough. Do we want to say 8 AM then?
Noon, something reasonable.
Noon feels right.
So we have a motion amended. Do we have a second?
Second.
We have a motion and a second. All those in favor signify by saying aye.
Aye.
Opposed?
Sean, you realize that noon deadline is for the previous one we did, right? We don't have to amend that.
Understood.
Okay, thank you.
Please let the record show unanimous approval of the postponement.
Members of the board, this is Amy Seibel. I just want to make one comment just so that the record doesn't reflect that. It's the job of the assessor to basically audit the response from an attorney. And so I hear his argument that, well, you didn't tell us that what we supplied was not relevant at all and was the wrong information for the property. I don't think that's our job. I think it's their job as the attorney representing the property owner. When they submit documents in compliance with the subpoena from this board, it's their job to make sure that what they're supplying is the right information for the property. And so I don't think that they should be getting off the hook. I'm in favor of giving them another week's time, but I don't think that they should just not have to, roll up their sleeves and do the work and find out and find the information, as opposed to us having to sift through it and say, well, this is right, this is wrong. They have access to the client, we don't. And so as far as, saying that they didn't have enough time to figure out that what they had supplied was not relevant at all to these various different properties, I think it's just a red herring, that argument. So.
Your point is taken, but the board has made a decision to grant additional time. And the fact is, somebody has to review it, and in a review process, time can be a consideration. And the time window, I didn't hear any arguments as to the few hours that were provided after the concern was raised. So I think the board's decision and determination is reasonable to get the proper documentation to make sure that everybody has the necessary documents to make an informed decision. And if there's nothing available, we'll know that next time and we can proceed accordingly. So yeah, we don't want to let them off the hook. We want to make sure that everybody has exactly what they need. And part of the problem I have here is the transition. If there were building permits, we didn't get them. And so it's hard to say that we did our due diligence and not going to the city of Madison and saying, did you have building permits for these properties? And I didn't hear anybody say they did that. So I think they have an opportunity here to either go to the city of Madison now and that we can find them, or the taxpayer's representative can work with his client to make sure that they have provided the proper documentation as requested. So I think we reached a fair ground as far as making a determination to give everybody equal opportunity to make sure they have the documentation necessary to support or adjust the value in question.
Mr. Chairperson, could I ask a question on top of that? Just to make sure that everyone's expectations are set for the next time we meet. If the taxpayer comes back and says, hey, we've delivered all of the documentation that we have, and we say, we still believe that there was building or enhancements done to the property, but we do not have any permits as a city to show, are we not going to be in this same spot that we are right now? Or maybe to ask in a different way, I have a problem with holding a taxpayer to show proof of documentation for a permit that we cannot even prove exists. So is that what we're also asking, that we're asking the city to say, if we're going to tell the taxpayer your documentation is insufficient, we need to be able to show them the permit that they pulled that they're not showing the documentation for?
There's no requirements that the assessor has to have permits. The taxpayer would have records that would not be only building permits, but they would be other tax records. if they've made improvements, capital improvements to the property, they would be deducting those on their tax reports. So they have access to documentation that the assessor doesn't have
Gotcha.
access to. So that's what we're asking them to go back and check. Make sure that they have reviewed all of the records, and then they come back and say, we have nothing. They're under oath. We'll have to respect their position under oath as well.
Gotcha. Thank you.
This is becoming an interesting day. I thought this would be fairly straightforward. Agenda item 6B is taken care of. Let's move to 6C. Zimbrick Buick, Inc., parcel number 0709-344-9402-0. So I defer to the assessor on this property as to what he found and received.
So for this one, subpoena item number 4 states copies of any leases or other documents that show the amount of rental income paid to the property owner for the use of or rental of any portion of the subject property for tax years 2020, 21, and 2022. No lease was provided and no documentation showing any amount of rental income being paid to the property owner was provided. In the email that I sent the other day, I wrote on a letter, let's see here, subpoena item number 4, the response from the authorized agent suggests that there's no written lease in place, yet on the letter they sent responding to our request for income and expenses dated 6/13/23, they state that there's no written lease in place. However, in 2022, a total amount of rent was paid by related entities for the car wash and storage in the amount of $339,335. Excuse me. The 2 other Zimbrick properties we issued a subpoena on, leases were provided. It seems odd that the other 2 would have leases, but this one does not, but maybe I'm just missing something. The taxpayer's representative responded and said, for some improvements, we charge rent to ourselves for comparability to other locations. There are no leases, and this is for a separate building like the car wash. Zimbrick paid for the improvements, and Zimbrick Incorporated charges rent to the different franchises on this campus. The rent is simply for bookkeeping purposes. So from what I understand on this parcel, there is a Buick dealership, a GMC dealership, an Infinity dealership, and I believe maybe a used car one, although that might be mixed in there altogether. But those separate, whether it's GMC, Buick, Infinity, they pay rent to Zimbrick, the property owner. And while there may be no written lease in place, there was no evidence other than saying, here's what we received for car wash and storage. There was no indication of any rental income that was paid on behalf of the other dealerships, GMC, Buick, whatever. So I believe for that reason, this subpoena has not been complied with, and this one I would move to dismiss as well, given that not the full scope of information I believe was provided. Thank you.
Again, I'll just kind of reiterate the point in the email. The question was, it seems odd that you wouldn't have leases. He seems to acknowledge that there aren't leases because it was explained they're between related entities. To the extent that he's indicating that, as he pointed out in his question, that he saw an amount of $339,335. The request was for copies of any leases or other documents to show the amount. So if they're seeing documents that show this other amount, whether or not it's included in income statements, we've already indicated that there are no other leases. We provided that response. Again, we got no response back indicating that that was insufficient. So I'm not necessarily sure what more he's looking for that we haven't already provided as it relates to this property.
So you're saying you don't need more time on this one?
Well, I'm still unclear what he's thinking that we need to provide that we haven't already. He's indicated that we haven't provided leases. We've explained there's not leases. So I guess I don't know what piece is missing and why that's insufficient.
Help me with clarification on, this is a large parcel on the entrance of our community. And they've had multiple dealerships there for many years. There's also, I believe, an office building. Am I correct that this includes that office building?
I believe so. Let me double check the GIS map. The office building is actually a separate parcel, it appears.
Okay, so we're not talking about an office building
No.
which would have multiple tenants possibly. We're just talking about the dealership, Buick. How about Honda? There's a Honda dealership on the corner.
Yes. So, yeah, there's, call it 3 separate buildings on this parcel with varying dealerships of different brands, Honda, GMC, I believe Infiniti, Buick are the 4 main ones.
So this
And
goes-
to my knowledge, there's, based on prior communication I've received, there's income that gets generated on the part of the property owner by GMC, Buick, Honda, Infiniti. And I've not received that.
So just as a point of clarification, when you say income, you're talking about lease agreements from those dealerships to Zimbrick?
So the subpoena requested copies of any leases or other documents that show the amount of rental income paid to the property owner. And if there's no leases, that may be fine, but there was also a request for other documents that show the amount of rental income paid to the property owner, and none of that was provided. There's no other documentation that shows the amount of rental income that was paid.
So like checks from some entity to Zimbrick?
Right, or even, a receipt of those payments, anything like that.
Okay.
I mean, that's certainly something we can check, based on the question that was posed to us and based on the response that was provided. The rent, quote unquote rent, was put in quotes in the email. And so I'm not necessarily sure how Zimbrick treats it. And so when we ask them if they've got any documents showing the rent, they don't seem to necessarily call it rent. They use rent in quotes because that's what the assessor was using. As far as it seems, it's very clear that we don't have any leases. So I think that's clear. I can certainly follow up to the extent that they have any other documents showing rental income and explain that rental income is how the assessor is defining rental income and not necessarily how they may deem rental income. If you have a lease, you have rent. They don't have lease, they're not maybe looking at it as rental income. I don't know, but that's what I would request time to do.
Okay, I guess we've set a pattern. Variation in terminology as to how things are handled within the bookkeeping system of the company versus what the assessor is looking for in this particular case. Different item, but certainly important. I can't imagine they just use the building, and I know it's under Zimbrick Inc.,
So,
and not have some kind of reasonable compensation for using the property. So
So if we give this, which we probably will till October 6th at noon, are we talking the same thing here? I mean, is he going to say a week from now that you asked for something and then we don't even know what it just seems like it's kind of this back and forth. You ask for something, he doesn't know quite what you're asking for, and it's just this paddle ball back and forth here. Are we both under the understanding of what we're asking from each other or what we're supposed to provide?
I think I feel that I've kind of made it clear what we're looking for. If Sean has any questions, I'd be happy to answer them. And if and when the information does come, I will make a concerted effort to review it as quickly as I can and get back to them with any issues.
Okay, and we'll certainly follow up and make sure that what we provided answers that and that there isn't any so that we're not here having the same
Right,
conversation.
because otherwise this is a delay, not a delay tactic, it's just,
Sure.
what are we doing here?
Question for you, Sean. But at this point in time, do you fully comprehend his request and what he demands at this point in time?
So my understanding, and I'm looking at the subpoena request for production, request number 4, which for leases, and I think he's looking at, and other documents that show the amount of rental income paid. He is looking for other documents showing the amount of rental income paid, regardless of whether or not any written leases exist, which don't. So any documents that would support any amounts paid by those other entities to Zimbrick Inc. Is that correct?
Correct. Yeah.
Okay. That's my understanding.
So if I may just be crazy and tender a differing opinion, I actually think the assessor's question on this property was quite clear. I think in the email, it clearly states leases or documentation that dictate other income or whatever that second sentence was. And this one, I am personally starting to feel like is a little bit like, Amy, I'm so sorry, I forgot your last name, but legal counsel, and when Amy, when you brought up the fact that there is a burden on the taxpayer to provide documentation that is asked of by the assessor. And in the first two cases, I felt like we were saying, well, we don't know, or we don't, that was a little more nebulous. This actually feels quite clear cut, and it feels like the taxpayer missed providing this documentation. So I don't actually know that I'm in the camp of not waiving this. I think this was much more clear by the assessor in his request of the taxpayer.
I can clarify in the email for request number 4 that was sent on Monday at 8 p.m. The comment was that there were no written leases in place. The answers that we provided, again, there were no written lease in place. However, 2 other Zimbrick properties provided leases. It seems odd that they wouldn't have any leather leases. So all the questions, the key word in here was leases. And so we reiterated, we don't have any leases. We don't pay quote unquote rent. So I understand the board members' comments. However, just wanted to clarify that the focus on the question in the email was all very, very specific to leases. And so that's why I think it is different. And I think we can try to clarify what we have. If there aren't any leases, what potentially we might have that would show the rental income paid.
And just so I understand, if we dismiss this as you're requesting, then your decision already, assessment would stand, and then this would likely be appealed and move on to court, right?
Well, they wouldn't be able to appeal it in circuit court once the board dismisses it. They could, take it to court to appeal the decision of the board to dismiss it, but they wouldn't be able to.
Gotcha.
Yeah.
Okay. Thank you. And one more, the language, so according to Nicole, because I actually didn't read that part, but the language in the subpoena did say, and other documents.
Yeah, it says copies of any leases or other documents that show the amount of rental income paid to the property owner for the use of or rental of any portion of the subject property for tax years 2020, 2021, and 2022.
Okay, yeah, I think I'm leaning toward Nicole's perspective on this issue with this one.
Some interesting topics and challenging as far as semantics in the subpoena requests that were submitted. Any other discussion? At this point then, I'm at a point where I think we should ascertain a motion as to which way to proceed.
So I would, you might have to help me with the language. I would move that we accept the assessor's recommendation and dismiss the waiver request, or dismiss item C due to insufficient subpoena compliance.
Okay, we have a motion. Do we have a second?
Second.
And again, so that everybody's clear, this is a motion to dismiss because of fully complying with the subpoena request, the subpoena that we issued.
Chris, what is the final assessment then that will go in the book if this is dismissed?
Bear with me 1 second.
10-142-800.
Thank you.
Well, I'm going to read it in record.
Total assessed value, I would stand at $10,142,800.
Thank you.
We have a motion and a second. Any further discussion? Hearing none, I'll call the vote. All those in favor signify by saying aye.
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 Opposed?
No.
Nay.
Please let the record show that we had 2 dissenting votes, but the majority of the board approved the decision to deny this appeal. Do we need to take a short break?
Can we just for item 6D, can we share with the public why that was withdrawn, Chris, or not? Just curious.
Amy may have more insight on that. So they withdrew, well, I can tell you this. So they had a pending circuit court case.
Correct.
And that circuit court case was dismissed in, I believe, July. I can double check the specific date. But they withdrew their circuit court case, and the question was, is the Board of Review case for 2023 also going to get withdrawn? And I think at that point, they withdrew it. Amy, you may have more context to add to that, but.
And we don't need any official action withdrawing it?
No.
Okay. I would ask Mr. Chair for a 5-minute recess.
My Wonder Watch says it's 1:20. Let's reconvene at 1:30. Let's get it. We're returning to our activity after our break. We are now on agenda item 7, subpoena compliance review and possible consideration of waiver for Foley and Lardner for Novation Senior Apartments. Agenda item 7A. I'll defer to the assessor as to what he got in the subpoena request.
Sure. So 7A for Novation Senior Apartments has withdrawn their objection. We worked with them throughout the open book process, and they don't believe they responded to the subpoena. I think they just simply withdrew at that point. So that that's the story on that one. 7B, with respect to Artisan Village, this morning and over the past several weeks, our office, along with attorney Amy Seibel and opposing counsel, have been working towards a resolution on this one. We were provided sufficient, to put it lightly. We got a ton of information from them that was very useful in determining what the appropriate assessment should be. And as such, we have come to you, the board, with a stipulated value that both our department and opposing counsel and property owner have agreed to move forward with a value. So no hearing theoretically would need to take place. So, Amy, do you have anything else you'd like to add on to that?
No, we have prepared. I have signed on behalf of the city, and Attorney Eric Hatchell has signed on behalf of the property owner a stipulation that we'd like to present to you today that not only affects the 2023 valuation, but it also disposes of the pending litigation for 2021 and 2022. So we would ask that the board consider the stipulation that deals with 2023 at least, and we think it's a favorable resolution on behalf of the city, and would urge you to adopt the stipulation and sign on the bottom if you do so choose to accept it. And the assessor can read into the record what the assessment was and the property
Sure.
tax parcel number and what it is revised to be pursuant to the stipulation.
Sure.
Okay.
So it's for two separate parcels. They are assessed together. Parcel number 0609-012-86052, address 207 Oregon Road. It's 102 apartment units there. The other parcel is 0709-354-98650. Address is 2775 Novation Parkway. There is 67 apartments there. The current value, as stated on the assessment roll for the two parcels, is $2,535,000 for the land, $12,093,500 for the improvements, for a total assessed value of $14,628,500. So again, that's for two parcels, for both the parcels that I read. The value is carried on 207 Oregon Road, parcel 0609 012 86052. As agreed upon by both parties, the stipulated agreed upon value, the land remains the same at $2,535,000. The improvements gets reduced to $11,272,300 for a total assessed value of $13,807,300.
Chris, congratulations, I guess, for coming up with consensus on this. What was the reason, if you could share why the $1 million drop in improvements on your end?
Sure. So there was a fairly lengthy discussion between both parties as to some of the discrepancies that were provided in some of their audited financial statements.
Sure.
There was some questions that we had with regard to, I believe, management fees and several other items that, after getting further clarification from the property owner or the opposing counsel, we kind of followed what they were saying, and we were able to come up with the correct value.
So you're asking this board to do what?
To reduce the value by, I don't know the exact amount, but I can get it for you.
And I might add, members of the board, that this property, Artisan Village, is a Section 42 low-income housing project. And under Wisconsin law, actual income and expenses must be used to value subsidized housing. And so the initial assessment was based on the mass appraisal model, also assuming subsidized housing, but it was based on the model. And once we got the audited financial statements for the 2022 tax year, we were able to fine-tune the model to better reflect the actual experience at the project as far as income and expense.
And so the total reduction would be $821,200.
$821,200?
Yeah, $821,200.
Got it. Mr. Chair, would you like a motion on this one?
Absolutely.
So I would make a motion on item 7B to accept the agreement to the new improvement value of, I guess I lost that number, of $11,272,300 for the property of Artisan Village, parcel number 0609-012-8605-2, as agreed to by City Assessing Attorney Amy Seibel and Artisan Village Attorney Eric Hatchell.
We have a motion. Do I have a second?
Second.
Any question? Basically, from getting the information detailed from the subpoena, the assessors reached a conclusion with a different value. It appears as if they've accepted by the property owner as being fair and equitable. So we have a motion and a second. All those in favor signify by saying aye.
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 Opposed? Hearing none. Let the record show it was a unanimous vote. And I am signing the order, and we'll give it to the clerk. That takes us then to agenda item 8A, Realty Income Corporation, AMC Theater. She wants it in duplicate.
Always in duplicate. Thank you, Chair.
I will defer to the assessor as to what's happening with this particular appeal.
Sure. So thank you. For this property, we are still have having ongoing discussion with the property owner. There's some clarification that we need that we're waiting on from opposing counsel on some of the subpoena documentation that has been provided thus far. I would say the compliance with the subpoena has been sufficient, but we still need additional time to confer with them with some of our questions, and there's kind of a back and forth that they have some questions for us as well. So we're working towards a resolution on this one way or another. And so we just asked that the board table this to the next meeting.
And I could add some additional information. This matter it's currently pending in circuit court for the 2021 and 2022 tax years. And we have been in numerous discussions with opposing counsel, who is the same counsel for Artisan Village, Attorney Eric Hatchell. He could not be here today. He's attending a funeral. But we are very close. In fact, we were going back and forth this morning with some numbers. And so by the next meeting, I am confident we will have a stipulation similar to what the board just accepted for Artisan Village for this property, that hopefully will not only take care of the 2023 tax year, but also, perhaps might dispose of the earlier tax years that are currently pending in court.
Okay, so I hear a recommendation from the assessor that we table this until our next meeting, so that hopefully a resolution can be reached, and not only the 23 assessment can be satisfied, but also for prior years as well. Do I have a motion to table this?
I'll move to postpone this until our meeting in October.
I'll second.
Postpone or table? That the same thing?
Yeah. Postpone and you're going to come back to it, table, and you're...
Okay, so postpone. Okay. Good catch, Carol.
So we are postponing, the motion is to postpone this until our next meeting in October, which date hasn't been officially set yet.
And for the record, Sean, are you seconding?
Yes.
Well, there were multiple seconds, so
Whatever.
everybody's in favor. Everybody's in favor. Put all of us down. Since we're all in favor, I'll call a question. All those in favor, please signify by saying aye.
Aye.
Opposed? See, I told you we're all in favor.
Heat of agreement, Mike.
Agenda item 9, moving on, subpoena compliance and review, consideration for waiver for Vaughn, Reason, and Roper. Items A and B are Fitchburg Apartments. I'll defer to the assessor as to what's happening here.
Thank you. So these next 5 agenda items, I'm going to throw another curveball at you a little bit on this one, but if I may, part of, I think fairways, so items C, D, and E may be beneficial to move up in favor of A and B, if the board would entertain that.
So you're requesting that we look at Fairway Apartments, which is agenda item 9, C, D, and E,
Correct.
and just reverse the order with Fitchburg Apartments and Pines Apartments and put them at the end of agenda item 9.
Correct, yeah.
I'll make a motion. We do that. Any question or concern?
I'll second.
We have a motion and a second. We'll start with agenda item 9, C, D, and E, which are all Fairway Apartments.
Aye. Saving you, Mike.
Overachiever.
All those in favor, please signify by saying aye.
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 Anybody opposed? Okay, we are now looking at agenda item 9, C, D, and E. I'll defer to the assessor as to what response they got.
Thank you. So this specific property, it's obviously 3 different parcels, one kind of under one ownership, and we subpoenaed them on one subpoena. We believe that there's an outstanding appraisal that has not been provided. For context, there is a HUD-backed, Housing and Urban Development-backed mortgage. And with that, and that was taken out in 2021. And with that, we received a closing statement on that mortgage. And there's, it's I believe we have it valued at somewhere in the neighborhood of $33 million, and we believe that there's an appraisal with that that's not been provided. The reason being, and I'll give you guys a copy here and copies of it in just a second, but the closing statement that we were provided, there is a third-party reports expense on there to the tune of about $15,000. We believe that that is for an appraisal, and we have not received that appraisal. If that appraisal exists, it is very, very valuable information. It would help us derive what our, see where the value should be based on a third-party appraisal. So I'll hand these out in just a second here.
Thank you, Fred.
Thank you.
So, to that end, if that appraisal exists and it has not been provided, these subpoenas would not be complied with.
I see we have a representative here.
Good afternoon, everyone. My name is Barry White from the law firm of Von Briesen and Roper. I do have a new agent authorization to file because I wasn't on the previous one, so I'd like to file that now, if that's okay. Or do you need it after the hearing?
So the original documentation that we received, the objection form, was filed by somebody else?
It was filed by somebody else, yes.
And so you're now representing the property?
From the same law firm. My partners were and they are still on this authorization. We just have an updated one that includes me.
Okay.
Should I file that now, or should
Yes.
we? Okay. And I've got one for each of the other agenda items that are under 9, so I will give you those as well.
Please hand them, please provide them to the clerk. So basically, you're just adding your name to the list
Exactly.
from the same firm.
What was your name again?
What's the question, Rich?
What was your name? I didn't get your...
Sure, it's Barry, let me get to the microphone. Barry, B-A-R-R-Y, last name White, W-H-I-T-E.
Oh, famous.
Well, yeah, give me your best shot. I'll see if I've heard it before. I think the crucial aspect of the assessor's presentation is he said, if a document exists, it's important. And the fact is, we've inquired of our client. Our client does not know if such a document exists. What we confirmed to the assessor was that if HUD did an internal appraisal, we have no knowledge of it. And it certainly isn't something that's within our possession. We can't obviously produce something that doesn't exist. And we can't produce something that we don't have. We have produced everything that we have, all the appraisals that we have. And therefore, we have fully complied with the subpoena. And even the assessor here today can't say we didn't give him an appraisal. He said, if there's an appraisal, we would have liked it. Well, we don't have it, and we don't know if such a thing even exists.
Can you explain to us then what the $14,925 is for?
That I do not know. That is news to me today, that the item on a closing statement suggests that there was an appraisal. There was an email exchange between Attorney Seibel and one of my partners where she said something to the effect of, are you saying that you paid for an appraisal but don't have it? And we didn't know what that meant, where they got the idea. That was the extent of the reference to having paid for an appraisal. So I simply don't know. But again, we come back to, complying with a subpoena requires you to turn over that which you have. And we don't have it. We gave them everything we have.
Chris, is the 15,000 roughly number kind of what a standard appraisal cost for a project that we're looking at here?
It's in the ballpark, yeah.
Okay. And Attorney Seibel, has this, in your years of experience with other communities, has this practice been used where we kind of say that we think this number is for appraisal or something, or is this something that you guys just kind of came up with? Not that you came up with it today, but I'm just trying to say, give us some direction here of why this was chosen.
Sure. As you can see on this closing statement, there was a $22,750 million mortgage that was granted in 2021. In my 43 years of experience, I have never seen a mortgage granted in such a large amount without a supporting appraisal report. And so I agree with Attorney White, who, by the way, we practiced together many, many years ago at a former law firm for both of us. They don't have to turn over anything that's not within their possession, but they do have to turn over documents that are within their control. And since they paid for if this is an appraisal, I mean, we don't know for sure, we're raising the question. If they paid for it, in my experience also in practicing law for many years, is that when you pay for an appraisal, if you request a copy of it, the lender will give you a copy of it. And so they may not have it in their possession right now, but it certainly would be within their control to ask for it and to get it. And so we are not asking, the compliance was substantial on these three properties. And so, but we would really like to have that appraisal report because it's very recent. And also on these properties, as a result of the subpoena and the substantial compliance from the taxpayer, we are looking at a reduction on this property. And so before we come back to the board with a request for a reduction, we would like to make really certain that that's a fair number for the taxpayer and for the other members of the community. And so to have that appraisal report, which is very recent, to support the number of the reduction that we will be coming back to the board with would be very, very helpful. And so we would ask that the board ask the taxpayer to ask the White Capital LLC for first of all, find out what that report is and see if it is in fact an appraisal report. And if it is an appraisal report, to ask for it and to get it and to turn it over to us.
I have a question on the timing. When did you get this closing statement? Can you give me an approximation?
Would have been before the due date or around the due date, which was September 13th. I can't say this, I can tell you the specific date in just a second.
It was September 12th that we emailed and sent a link for all the documents.
Thank you.
So you've had this since September, and when did you ask for additional information?
So there was, let me look, there was several hundred pages of data provided, and Amy and myself had kind of finally combed through it this week, and it's, you know, in those several hundred pages of documents, when her and I were looking at it this week, we discovered that third party reports charge. And so, go ahead.
I'm sorry, the follow-up request came to us this Monday at 8:22 p.m. from Attorney Seibel.
So you had several days to respond.
And we did, and said that we confirmed that our client has no knowledge. If HUD did an internal appraisal, we don't know about it. With that said, so my record is clear. Let me point out that the legal standard for control, and Attorney Seibel is correct, that subpoena compliance requires you to turn over things within your possession or under your control. But the standard, as I understand, for control is whether it's in the possession of your agents. You can make your agents give you things, but control doesn't mean I can go out and get it for you, or I have to go out and try to get it for you. With that said, Mr. Chairman, we did. We had the clients email the lenders to ask them for the appraisal. And if we get them, we will, I have no problem providing them. But one of the other later agenda items, the lender responded, oh, we'll check with underwriting and look into it. So at least we got a response. On this one, we got no response at all, which just goes, I think, to the point of control. I can only do what I can do, and I think certainly the board has the ability to subpoena the lender.
What seems to
We
me,
were unaware, by the way, that they asked the lender. That information was not communicated to us. I'm hearing that for the first time today, that they asked the lender, what is this? Is there an appraisal? And that the lender either didn't respond or said, we don't know.
To be clear, we didn't ask, what's this $13,000? I didn't know about that. We asked for each of these number 9 agenda items, we asked our clients, go back to the lender and see if you can get an appraisal. One lender responded, we'll look, if there was an appraisal, see if you can you give it to us. One of the lenders responded, we'll check with underwriting and see if there is one. The one that we're talking about right now, for Fairway Apartments, we haven't heard anything back from the lender.
well, as you can see, my concern was, did you have reasonable time to reach out and ask specific questions about what was being asked for? And it's pretty obvious to me in looking at this third party, it doesn't say appraisal, it says reports. But as has been presented by Attorney Seibel, nobody lends millions of dollars without having documentation to support that. So I see third party reports. Pretty sure that you can assume that's the appraisal report. And if that's on this document, and they pointed this out, and you had some time to hopefully get it, I mean, we have a time frame we have to work within as well. We can't continue these things forever. At this point, I would say you haven't complied under the strict guidance of the subpoena that we sent you.
I'm sorry, we have or have not?
You have not
Okay.
complied under the guidelines of the subpoena we sent you. That's my opinion. It's not the board's opinion at this point. So I'm going to open it up for discussion as to what the board feels we should be doing in this case, as far as the assessor's recommendation is to dismiss the appeal for noncompliance. So we have...
No, that is not our recommendation on this particular property, because an adjustment is in order. And so we wanted that appraisal just to confirm the number that the assessor is going to reduce the assessment to. So we don't want it dismissed. We do want to reduce it and come back. And so we would, because we want a fair assessment. And there was substantial compliance. It was hundreds and hundreds of pages. So what we would ask is that the board give them 1 week's time to nail down and get that appraisal report and submit it to us, and then we'll come back with the stipulated amount to the board.
Has this revised value been shared with the property owner's representative?
Not yet. We were waiting for the appraisal.
I will do my best to get the appraisal.
Okay.
If Mike, real quick, Mr. Chair, if it were dismissed, would that take out what Attorney Seibel's saying, a potential reduction in their value?
It would eliminate it.
It would. So if we dismiss this, we then are not allowing the city to weigh in to say that the assessed value should be reduced.
Right.
So if Mr. White, I know he's going to, if we do give him a week and he can't find it, do we still, as you as assessing department, willing to consider the reduction or suggest the reduction in value? Or is it based on...
Yeah.
Okay. So we
Okay.
clearly, okay.
So we're going to postpone this, is what the assessor's asking for.
Yeah.
And I guess that, after hearing their attorney's presentation, it seems reasonable. But I would also encourage them to share with the property owner's representative their current opinion of the market value of this property or the assessed value, so that possibly we could reach a stipulation without having to make extra burden on all parties involved. So based on the documents you submitted, they've reached a different conclusion than they originally had. I'd certainly like to know if that's acceptable. Sort of like a plea bargain, I guess, but it's not truly a plea bargain. so that that can come back to the board instead of having you spending hours trying to find something that we'd certainly like to have had, but if we can reach an agreement before and settle this, I think that would be the most prudent way to proceed.
Well, we do want it because it will help to support, we believe, will help to support the value so that if the matter does proceed into circuit court and it's already in circuit court for a prior year, we would really like to have that appraisal before, suggesting a stipulated reduction. We really would like to have it.
Okay. I understand that very well, because if there's documentation that has been prepared and substantiates the belief you have, it's great to have it. And the challenge has been getting it. We can see that. So we're back to where we were. We're going to add this to our agenda for our next Board of Review scheduled meeting. So I'd ascertain a proposal to postpone this until our next meeting in October, so that I guess it was October 6th, wasn't it?
No, that's,
At noon,
that's the due date.
The appraisal would be due.
to get the info.
I'll make that motion.
So we're moving C, D, and E, items 9, C, D, and E, correct?
Correct.
I'll
All three
second.
of them, all three of them, right?
Correct.
And I'll second.
So, okay.
Can we take a moment to clarify on the due date for the submission for the documentation required?
Submission would be that the appraisal report be provided to the assessor by noon on October 6th.
Thank you.
And I realize sometimes getting big bank organizations or whoever underwrote this to comply that quickly can be a challenge. But as I said, I'd also like to make sure that there's some discussion on the documentation that has been provided so that everybody knows what your position is currently, so that you can all make an informed decision as to what's the best avenue to proceed.
Noted.
Okay? So we have a motion, clear as mud. All those in favor signify by saying aye.
Aye.
Opposed? Please let the record note it was a unanimous decision on agenda items C, D, and E, 9, C, D, and E, that they will be postponed until our next meeting. Okay, moving back then to our adjusted agenda for items 9A, Fitchburg Apartments.
So-
Mr. Chairman, could we take B out of order? Because it's the similar situation. Attorney White referenced that they're trying to track down an appraisal, and I believe it's for Fitchburg Pines Apartments, that the board have the same, we would have the same motion and the same request for item B, Fitchburg Pines Apartments. That's a 2020 financing mortgage.
So do you have some indication that there was an appraisal report? Like you
We
did
do. There was a refinancing that occurred in 2020, we because there was a refinancing based on prior experience, there typically is a mortgage anytime there's a refinancing. Or I'm sorry, there's an appraisal anytime there's a refinancing of a mortgage.
But you don't have a closing statement like you did on the last one showing that there was a substantial expense for a report.
We did not get a closing statement at all. They did not submit a closing statement.
Okay.
Even though we did ask for all of the loan documents that were executed in connection with that mortgage. We did not get a closing statement.
So I guess my question is, do you feel they're in compliance with the subpoena?
That property also is likely to be adjusted, and so we would ask that you postpone moving on that until to give them time to find the appraisal, and also then for us to have discussions with opposing counsel about where the assessment is likely headed.
Okay, Mr. White, the assessors, from what I'm hearing from the assessor's attorney, is that they feel that there should have been an appraisal report for this property as well. Again, we're talking Agenda 9B, the Pines Apartments. And they're
Right, yeah, no, right, I understand that's their position, and my response is the same, that my client doesn't have any knowledge if there is one or not. I can't produce that which I don't have, but we have asked for it, and we'll do our best to, if there is one, to get it and provide it.
So we're asking you to do that and have that completed by October 6th at noon, as we did in the last consideration.
Will do.
So I need a motion for agenda item 9B, Fitchburg Pines Apartments, to postpone until October 6th at noon, or to have it submitted by October 6th at noon, the documentation required by the subpoena, which is specifically the appraisal report that should have been prepared when the property was refinanced.
So moved.
Second.
All those in favor signify by saying aye.
Aye.
Opposed? Hearing none, again, let the record show unanimous postponement, approval of postponement until our next meeting. And just as in the last situation, I would hope there's communication between the assessor and the assessor's attorney with the plaintiff's attorney to make sure that everybody is looking at things that seem reasonable so that we can, again, hopefully find an amicable solution to the question that's on the table. Now let's go back to 9A for the third time. Maybe we can finish it this time. I'll defer to the assessor as to what's going on.
So this one, kind of the same story. We believe there to be an appraisal out there. And again, an adjustment downward is kind of warranted, but we need those appraisals to kind of validate that. So we would just request that the board postpone this similarly as the other ones, until opposing counsel can try to get that appraisal.
So it's unanimous.
Yes.
I will let the board know that this is the one lender that responded to us and said that they would look into it. And so at least we're getting communication on this particular one.
Okay, back to the table. As in the other four that we've looked at in agenda item 9, the assessor's asking this be postponed until our next meeting with additional documentation provided to the assessor by October 6th at noon. Do I have a motion to that effect? Motion and second. All those in favor signify by saying aye.
Aye.
And for the third time, please open the doors of communication so that the parties involved have a good idea as to what opportunities are available for settlement. I never thought we'd get here, but we are at number 10.
Thank you, everyone.
Thank you.
Thank you.
Subpoena compliance and review, consideration of waiver for Alpin and Ringsmouth LLC, Hy-Vee property.
So this one, we issued two subpoenas. This is it's the Hy-Vee over on 2920 Fitch-Rona Road. We issued a subpoena to the property owner, Fitchburg ZC Essential DST. The property owner complied with the subpoena request. We also issued a subpoena to Hy-Vee, who is the tenant in the property, for a number of documents, and they did not provide us anything. Some additional relevant information on this specific property. We were in mediation with them on, I believe it was Tuesday, at which point an offer was presented to the council later that night for a settlement agreement. The council had rejected that agreement. The following day, Hy-Vee dismissed both cases for, I believe it was 2020 and 21, but maybe it was 21 and 22, I can't recall. But in any event, they have not complied with their subpoena. They have dismissed their current circuit court litigation with similar values. I would request that the board dismiss this hearing based on noncompliance with the subpoena request.
So I understand correctly that the city council was presented with a option on Tuesday night of this week,
Mm-hmm.
and they didn't feel it was reasonable?
No.
They denied it?
Yep.
Okay.
Can I ask the city attorney, our attorney, to come up and just walk through what the council, just explain, if you don't mind, that action, what happened, Val? Just so, that's a little new wrinkle that I've heard.
Absolutely. So I can't go into details of what was discussed during the closed session, but I can tell you that
Please
Hy-Vee,
identify yourself for the record.
Valerie Zisman, city attorney. The council was presented with an offer to settle from Hy-Vee, and the council rejected that offer by a unanimous vote. That happened this past week, Tuesday. And it's my understanding that on Wednesday, counsel for Hy-Vee indicated they would be dismissing their pending circuit court case. That's for years 21 and 22. Doesn't necessarily have anything to do with this year's objection. This is a separate year and a separate objection, but that's the information I have to share.
So Hy-Vee came to the city proactive? I mean, what was the reason?
So what happened was that there was a previous lawsuit against the city for years 2019 and 2020.
Correct.
The city had prepared it for litigation, and on the eve of the trial, they dismissed that. So, of course, they're not prevented from filing additional suits. So they filed another lawsuit for year 21 and consolidated year 22 into that suit. And they have now dismissed it, fortunately, not on the eve of the trial, but several weeks ahead of the trial. But the trial was scheduled for mid-October, so in just a couple of weeks here. So after the offer that they had tendered to the city was rejected by the council, they decided, for whatever reason, to decline pursuing that in court. So that case it has not been dismissed yet formally by the court, but it's my understanding there's an agreement by Hy-Vee to withdraw and agreed to dismiss their suit.
And for clarification from the assessor, the information you requested from Hy-Vee under the subpoena is valued in a similar fashion as to the property values in the prior years?
Yeah, I believe it remains unchanged from prior years. I can get you the specific information.
Members of the board, also as part of discussions this week with opposing counsel, they were advised that the city assessor would be asking the board to dismiss their 2023 objection today for failure to comply with the subpoena.
So for from 2022 to 2023, the value was unchanged.
Okay.
I'd make a motion to dismiss item 10A.
I would second that.
We have a motion and a second to dismiss item 10A, which is Hy-Vee Inc., parcel 2920 Fitchburg Road, parcel number 0609-072-0015-2, based on noncompliance with the subpoena. So we have a motion and a second. Any additional discussion? Hearing none, I'll call the vote. All those in favor signify by saying aye.
Aye.
Opposed? Please let the records show a unanimous vote to dismiss agenda item 10A. Consider any new business. Consider act on scheduling additional board or review dates if needed. It seems like we have a need, and we are talking about getting the room, and the clerk has checked, and the room is available on October 12th. What time? 8 o'clock?
That's correct, October 12th at 8 a.m.
For how long? How long is the room available? Till noon.
Mr. Chair, before we adjourn, could maybe Attorney Seibel or Mr. Leitz just kind of tell us what we're going to be doing at the next meeting here? We're recapping. Hopefully very little. Hopefully, but I just want to know where we're at here.
I can respond. At the next meeting, the board will be considering several stipulations to adjust the value. There will not be any valuation hearings. There will be stipulations, much like what the board saw today in Artisan Village. And submitting stipulations and asking the board to approve the stipulations to change the values downward.
You don't anticipate any more delays in getting information and stuff like that? We're kind of past that phase, right?
We are.
Okay, thank you.
So we vote and get off the pot. But we do have potentially the Zimbrick properties. Potentially we could have hearing on.
Or waivers. Agreeing to, if there is sufficient compliance, there could be a request on the behalf of the assessor to not object to their waiver request. I believe all 3 Zimbrick properties have waiver requests.
Okay. Well, we'll have the room till noon. And if you have conflicts with that, please let Tracy know as soon as possible. Do we need a motion to set the date? I think we do. So I'll make a motion that we suspend today's meeting and reconvene on October 12th, 8 a.m. in the council chambers to try and conclude the remaining or outstanding cases for the 23 border review. Do I have a second to that motion?
Second.
All those in favor signify by saying aye.
Aye.
This meeting is finished. Thank you very much. I do have one thing I'd like to add. Rich, are you going to make an announcement? No, I'll wait till the next. Okay, thank you. I just didn't want to have it fly off the table. Okay. This meeting is closed. Thank you.
Thank you.